Good morning. Welcome to another edition of Coffee with Cartlaw, Alabama. You're not going to find me with coffee this morning because I'm actually recording this a little bit later in the day than I normally do, and I've already had my coffee, so I'm raring to go. You enjoy yours. Today, I wanted to talk to you about a pretty hot topic, and it's a proposed law in the Alabama state legislature uh, that would provide liability protection to businesses, to churches, to healthcare providers, and others in certain circumstances from lawsuits filed on because of COVID-19, virus-related causes of action. And let's talk about what that actually means. But before I talk about that bill, which has passed the Senate committee by now with a 27-1 vote, it's still not law. Not sure if it will be law. I think that there will be a law that gets passed, and it very well may be this one. But let's talk about what the actual sponsor of the bill says that it does, and that is Republican Senator Arthur Orr, who represents Morgan, Madison, and Limestone counties, proposed the bill, and he was interviewed and asked about that particular bill on Wednesday. And he said that it gives protection from virus-related claims to these entities only if they were following appropriate precautions. He said, quote, "A business that chose to ignore that guidance and did not require, say, like mask in their workplace or took no steps to try to limit the interaction of their workers being very close together, then they would not have protection in that safe harbor." Now let's talk about that for a minute. What he's saying is that I have a bill here that's proposed. It's going to give you a good defense to a lawsuit, but only if you fall within this safe harbor. If you do certain things, then you're going to be protected. I think actually the bill goes a little bit further than that and provides a little more protection than what he was telling the newspaper. I'm glancing over here to the side because I have the bill up here on my other screen, and I wanted to refer to it. Uh, the bill actually says, and I'm going to summarize a good part of it, that a covered entity, being your business or a church or a healthcare provider, will not be liable for any damages or injury or death that occurs as a result of this health emergency claim associated with the pandemic. However, that doesn't apply, the bill says, if two things. Number one, the claimant, that's the plaintiff in a lawsuit filed against you, proves by clear and convincing evidence, that's number one, that the covered entity caused the damages or injury or death by acting, number two, with wanton, reckless, willful, or intentional misconduct. Now, this is why I think the bill actually goes further than what Senator Orr actually says that it does. It's requiring a very high standard first in part one. Normally, when someone files a lawsuit, the plaintiff has the burden of proving their case by something known as a preponderance of the evidence. And that's just a fancy way of saying more likely than not. If you can picture the scales of justice as a 50-50 proposition, whatever makes those scales tip just a little bit more is a preponderance. And that's a normal lawsuit. Well, here they say, well, wait a minute, plaintiff, if you want to be able to pursue a claim because of a virus related kind of thing, then you've got to show by clear and convincing evidence. That's a much higher standard than just preponderance of the evidence. Clear and convincing evidence. So that's number one. The second part is normally in a lawsuit, if you're having someone sue because of death or an injury or something like that, let's say someone uh, runs a red light and hits your car, You sue them based upon negligence. That's a failure to exercise reasonable care under the circumstances. Well, here, mere negligence is not going to be enough. The plaintiff is going to not only have to show that higher standard, but they're going to have to show that you acted with wanton, reckless, willful, or intentional misconduct. Well, that's something well beyond just being careless. Now, I'll end this by telling you what I tell all my business clients. I think that to best protect your business, you need to act reasonably under the circumstances, with or without this legislation. And generally, if you act reasonably under the circumstances, you're going to be protected in most cases regardless, but certainly with this proposed legislation. What would I consider acting reasonably under the circumstances? Well, if you have workers who are working in close proximity to other workers, or interacting with the public, with customers, with suppliers or salesmen or anybody, then you probably need to have a mask requirement that your workers wear a mask. Social distance requirements is also a reasonable precaution to take in a circumstance like that. If you engage those type of reasonable precautions together with anything that looks anything close to this bill, you're likely to be protected against COVID-19 lawsuits, and your liability will be preserved. I hope you have a great day. You stay safe, mask up, get the vaccine when you can, and I'll see you next time.